got so motherfucking design on right now. Bring it down, bring it down, bring it down. I got 3 old thoughts on the block.
Tonight, a woman has been arrested after a video pops up on social media showing her beating a 3-month-old puppy with a belt.
As KENS 5's Mike Jimenez explains, the video has upset thousands in the community who are now calling for justice.
The video is heart-wrenching to watch, and we have to warn you, some viewers may find the video disturbing. The video is so horrifying to watch that we're only going to show it to you once. In a video posted to Facebook, Havana Miller is seen on the balcony of an apartment complex in the 12,000 block of Culebra, holding a 3-month-old poodle while whipping the puppy with the belt 17 times.
Shut up!
In the video, you can hear Miller yelling at the puppy while the puppy cries. The puppy eventually breaks away and runs into a corner. 2 more strikes follow. The video was sent to Sally Arnold, a member of several dog groups, on Facebook, asking for help. Arnold posted it on Facebook Friday around noon. Arnold says when she saw the video, it broke her heart.
I just was bawling, and I don't understand how anybody could do that to a dog who can't defend itself.
Immediately, people saw the video and wanted to help. Renaya Rubio saw the video and went to Miller's apartment. She told Miller through her Ring doorbell camera that she witnessed her hitting the puppy and offered her $300 for the puppy, or she would call police and show them the video. Rubio says Miller agreed and said she did not want the police involved. Then Rubio says the price kept going up.
She's like, I got him for $1,000. Like, the least I can do is $750.
Rubio only had $500, so she began asking for donations. The video started going viral and people were donating more money. But then Rubio says Miller now wanted $1,000.
We never got the puppy. Another source had called the cops and apparently had sent them the video. And so that's when the cops and ACS, I guess, got involved.
San Antonio Animal Care Services got a warrant and around 6 p.m. Friday picked up the puppy. ACS says Miller was arrested Saturday and is facing a charge of animal cruelty, torture, a 3rd-degree felony punishable between 2 to 10 years in prison. From what started as tears of sadness for Arnold turned into tears of joy after learning the puppy was now in the city's care.
I just want to make sure that she's not able to do this again.
A petition on change.org was started demanding the maximum sentence for Miller. At last check, more than 8,000 people had signed the petition. We did reach out to Miller, but have not heard back. Mike Jimenez, KENS 5.
All right, we are going to go on the record. The court is calling 2025 CR 001454, State versus Havana Dejanay Miller. Could I have parties announced?
Lauren Espinoza and Jason Garaham for the state.
Jody Sawyers and Jared Hall as attorneys for the defendant, Havana Dejanay Miller.
All right, and are you Miss Miller? All right, so we're here today to hear pretrial motions. I think it is best to start with the motion to quash, because if that were to be granted, then the other motions will not need to be heard. So the court is in receipt of the true bill of indictment, and the court is in receipt of the motion to quash the indictment and a memorandum in support of the defendant's motion to quash the indictment. State, are you prepared to proceed on the motion?
Yes, Your Honor.
All right, defense, you may proceed.
Yes, thank you, Your Honor.
Oh, you can remain seated because, and if you'll speak into the microphone, that way I can hear and the court reporter can hear.
Thank you. All right, so the issue with this statute is very specifically in regards to it's the torture provisions of 42.092. And what I mean by the torture provisions is in 42092B1, it says that if you commit torture or in a cruel manner kill or cause serious bodily injury, that provision, we're limiting it to the torture because the state has not alleged cruel manner of death, killing, or serious bodily injury. The definition of torture is an unjustifiable, an act that causes unjustifiable pain and suffering. And while that might sound, sufficient, it's super, super vague. And it becomes even more vague when you look at the rest of the statute and how in the allowable conduct that it permits under the statute. So I do have a copy of the statute. It's actually for the court. It's actually chapter 42, most of it. It's gonna include section 4209, cruelty to livestock, and then right behind that, it's gonna include
Oh, I'm sorry, you gave me 2 copies.
okay.
I don't know, the state may need an extra one. Thank you.
Do y'all need an extra one? Okay. And then right behind that, you'll find the cruelty to non-livestock at 42.092. When you look at these statutes between livestock and non-livestock, they are identical in regards to the torture provisions. The only difference is that livestock is limited to intentionally and knowingly, whereas you have the mens rea, and then non-livestock allows you to go to recklessly. So that's the only difference, is the mens rea. The definition of torture under livestock, cruelty to livestock, and cruelty to non-livestock is the exact same. That's important because when we look at what our society has determined is acceptable or justifiable pain and suffering, we have to understand that the context is the same regardless of whether the animal is non-livestock or livestock, even though this is pled under the non-livestock provision. Okay, then turning your attention to the actual statute of 42.092, I want to bring your attention to section B and B2. And it says a person commits an offense if the person intentionally, knowingly, or recklessly, without the owner's effective consent, kills, administers poison to, or causes serious bodily injury to an animal. So by implication, if you have the owner's effective consent, it is not illegal to kill, poison, or cause serious bodily injury to an animal. Then if you proceed downwards, it allows under B6, it allows that someone, if they have the effective owner's consent, to cause an animal bodily injury.
So are you saying that according to this part of the statute, if you are a pet owner, then you can poison your pet, you can beat your pet, and that's not a crime?
And that's what is concerning about the absurdity of this statute, but that is the statute. Basically what it's saying is if somebody else does it to your animal and you give them consent, it's okay. But read it, and that's what I'm saying. It says under B, a person commits an offense if the person intentionally, knowingly, or recklessly, without the effective consent of the owner, kills, administers poison, or causes serious bodily injury. So they can do it. It's not as long as they have the effective consent of the owner. So
isn't that related to if you take your doctor in for veterinary care? Well, you euthanize, have the animal euthanized, that you're killing the animal and the owner has given consent?
And that's a great question. But if you look further, it actually has a provision that deals with the like a veterinarian services. And let me see, it is a defense on D. Mm-hmm. It is a defense under that if the actor had a reasonable fear of bodily injury, if the actor was engaged in a bona fide experimentation of scientific research, or under E, if it was discovered on the person's property, or 2, the person killed, injured the animal within the scope of the person's employment as a public servant. And then it goes on, sorry, which one is it? So I don't think that well, I think that's a great question. I don't see the actual, well, but it's a public servant. So, I mean, I don't see where it says actually a doctor, but you see what the problem there is that you, by saying, oh, that's just to allow a doctor, it is not limited under the statute for that purpose. It's saying anybody. And when you look at animals, animals are considered under our statute or under our laws as chattel, as property, which is just the way our society has defined them. Whether I agree with it or I don't agree with it, the civil courts will not allow you to collect money, civil damages, if you, for the loss of your emotional attachment to a dog. And there's a case that we have on that. It's cited in the paper. We can provide that to you. So what they, and they do a great job of.
Well, that's civil.
I
We're
understand.
just here under the penal code.
Yes, Your Honor. And so, but the point is that the status as property is what is triggering the owner's, why you have to have the owner's effective consent, because our laws, whether they are civil or criminal, still see animals as property. They don't see them as having the same rights as a human.
But are you, even with regards to this section that says without the owner's effective consent, are you arguing that you can still kill an animal in a cruel manner?
I'm not arguing that. I'm saying, yes.
Or cause unjustifiable pain?
So that part I am arguing with, because that is so broad as to undo all the other rights that you would have. Because when you say unjustifiable pain, does that go to emotional pain? It's not limited. It doesn't even under, and that's why this is going to become such an issue throughout the course of this trial, is because if, as in our case, there's no bodily injury, then you are saying that the law allows for us to criminalize acts that someone just feels calls a dog unjustifiable pain and suffering without requiring any proof of bodily injury. Humans don't even get that level of protection. You know, humans, you can't be charged for having caused someone emotional, like with a crime, for having caused them emotional injury.
Is the indictment, are you all charging this indictment as causing emotional pain to the animal?
No, Your Honor, the indictment's charging under the first section under D1 that says torture.
All right. So they're not, my understanding, and if I'm wrong, please correct me. My understanding is nobody is charging her with causing emotional pain, allegedly causing emotional pain to an animal.
So if you have no bodily injury to an animal, then what's left?
Isn't that a fact issue for the jury?
No, I don't believe so. I believe that our law will not allow, like written as broadly as it is in conflict with every other provision that we have in our codes. Because if you look at the bodily injury, like for instance, a human assaulting another human, we specifically state in our definition of bodily injury that it is the
Causing pain?
Yeah.
One of them.
Well, it's causing pain, but the thing is that it also it will not allow for someone to be criminally prosecuted for emotional harm or pain. And we distinguish that by saying that it has to cause bodily injury. Here, the problem with this statute is that torture provision does not require bodily pain. If anyone shows that there was no bodily injury, whether, and it's a different topic, whether you could include pain or it would require physical bodily some type of visible injury, that's a completely different issue. But just assuming for the sake of argument that if we are going to require and limit assault to bodily injury on a human, we definitely can't not require it for an animal who, under our laws, has historically and still today gets less protection. I mean, a prime example is our horse racing. We have animals that are routinely raced and beat with crops. And the reason I bring that up is because this one specifically names repeatedly striking a dog. That's the manner in which they claim. So the point is that our society has said it's justifiable to beat a horse with a hard crop for horse racing and making money, and that's justifiable.
Well, that's something that needs to be taken up with the legislature on the fact that maybe people don't want horses being beaten. I know some people complain about maybe in other countries dogs are eaten for food, but then people have a different idea of how dogs should be treated as opposed to livestock, as opposed to horses, as opposed to chickens. But that's something for the legislature to change how different animals are treated and how they're treated in sports. So my understanding, and again, if I'm wrong, correct me if I'm wrong, the state is not charging your client with emotional abuse.
No, Your Honor.
So my understanding there that the indictment doesn't mention emotional abuse. And I know you're saying torture, but my understanding from this statute and from what the state is saying, they're not charging your client with emotional abuse of an animal. They're charging her with allegedly, recklessly causing torture or committing torture.
So first, let me back up and say that the legislature has, in their infinite wisdom, not distinguished between livestock and non-livestock for purposes of torture. And so we cannot say that animals, livestock should be treated differently than non-livestock. They all are examples of what a collective class of they're a collective class. So we can't distinguish it that way. But what the problem is not whether the state sits here and tells us what they've charged. It's that the statute itself, the underlying statute, is so broad as to encompass or not eliminate the ability for someone to be convicted, including my client, of an instance in which all that happened was, if anything, emotional harm to an animal. And that's the problem with the statute. Whether the state claims that they weren't trying to, convict someone for emotional harm, it's that when we get to the end of this and that jury charge, and I go and ask the court, hey, how are you going to keep them from convicting on emotional harm alone? The court's not going to have an answer because the legislature didn't give us the tools.
No, here's the thing. I'm reading the indictment. The indictment is stating intentionally and knowingly, recklessly torturing an animal. Like if the state were to just have left that as says torturing an animal, I would say your client really doesn't have notice. What are they talking about? But then in the indictment, it says, namely a dog, by repeatedly striking the dog. There's no mention in this indictment about emotional harm. And whether or not you believe a jury may or may not find somebody guilty because they're thinking about emotional harm, that's something that you'll need to argue with the jury.
And Your Honor, and that's where I'm saying I have an issue with the law itself. That's why it's filed as a motion to quash, because this is something that a jury, it can't comprehend how the laws are structured in our country. I mean, they haven't studied the laws like we have as lawyers.
But isn't that what a jury charge is for? I tell them in a jury charge what the law is, and they have to follow the law.
Yes, but you told them, and right now what I'm explaining is that there is no limitation on it being. So if what the court, if I'm understanding your question correctly, I think your question is, hey, can a jury convict on emotional harm? And that's the issue, because it is read that broadly. You're not going to be able to tell them no. You're not going to be able to tell them you must find at least bodily injury, however that's defined, because we as a society do not find emotional injury to be a criminal act. It would be criminalizing non-criminal conduct if we are saying you can convict on emotional harm alone. And that's the problem, is that when I ask you for the jury charge, you're not going to be able to give me a jury charge that is in line with how it is supposed to be in my opinion, it is supposed to be limited to bodily injury, but you're not going to be able to do that because the law is absent or silent on that. And also further, if we are to say, okay, well, it's silent, we can look at, and section under Texas Penal Code 105, it tells us that we are to read these statutes, these provisions, in line with the whole context of the Texas Penal Code to be a fair interpretation of the statute. And I have a hard time believing that the legislature allows us to give effective consent for someone to cause our animal bodily injury or kill, poison, and cause serious bodily injury. But they're like, but you can't cause them emotional harm, and that it goes that far. And so what I'm saying is that if there is a way that the state could have indicted this that would have limited it and applied it the way it was probably intended to be, they would be causing that they cause bodily injury by repeatedly striking the dog, because they then, in their manner and means, have limited it and said, look, we're talking about bodily injury here. We're not talking about whether the dog was traumatized with no bodily injury.
All right, state.
Your Honor, the definition of torture, we would argue, is intentionally broad because there is a wide variety of means at which an animal can be tortured. So in this situation, in McGinnis v. State, the court focused on the words unjustifiable to conclude that yes, under the law, there are some instances where infliction of pain and suffering is allowable, which is why the state must allege specific acts that were alleging the torture occurred through. So the court in Hacker v. State, as well as Cross v. State, said we need to allege those specific acts, as well as interpret the words unjustifiable, and in that case unnecessary, based on their common usage, because it's not defined. The state has done that here by including the clause by repeatedly striking the animal. Further, courts, when interpreting torture, they have looked at the physical condition of the animal and the side effects of that treatment. So in Solinsky, the court found that the nature of the condition of the cats by putting them in the microwave constituted torture. And in Bell v. State, they also found torture when the defendant amputated the puppy's ears without providing anesthetic and antibiotics. Those questions, whether defense finds the torture alleged sufficient based on, pigeonholing us into proving bodily injury of the dog, would be a question of fact for the finder of fact, so the jury. To fix, quote unquote, fix the indictment by adding bodily injury would be adding language that's not required by statute. And we would have been here in the same position arguing against a motion to quash for adding language that isn't there. We must only prove torture, and torture is any act that causes unjustifiable pain or suffering. Even using the definition of bodily pain that defense thinks that we should have as the scope for torture in this case, it's physical pain. Pain doesn't always leave a mark. It doesn't always require physical injury for someone or something to feel pain. In McCall v. State, the appellant challenged the constitutionality of the animal cruelty statute as vague and indefinite, relying on Senator. In Senator, they found that the provision there regarding needlessly killing an animal as unconstitutional. However, the court in McCall said that the court in Senator expressly only said that one provision of needlessly killing was unconstitutional, but that the statute listed and enumerated other ways that are sufficiently definite. So by tracking the language of the statute here, we would urge that our indictment is sufficient. And then by using torture, which is under B1, and then adding the manner and means to provide adequate notice. Regarding defense's argument about property rights, we would urge to you that animals, yes, they are property and they do typically have less rights than humans, but we'd extend that to say that they need more protections because of that reason. When somebody owns property, they own it under the guise that it might involve adjustment of that rights for public good. The whole purpose of this statute is that it criminalizes an act that causes unjustifiable pain and suffering. one can't own property and not have their rights sometimes yield to the government's legitimate exercise of its power to prevent harm to the community. We would just urge, Your Honor, that the statute is not unconstitutionally vague and that any issues regarding what may or may not be torture would be a question for the jury.
All right. And defense, it's your motion, so I'll give you final argument.
Well, and Your Honor, I still have, there's other
Sure.
things that we need to address. So I would like to provide y'all with a copy of United States versus Stevens, in which the federal government dealt with a statute very similar to this one. In fact, it was more specific. It said that the statute required proof of being maimed, mutilated, and tortured. And let me see, the U.S. Supreme Court said this statute is unconstitutionally vague, and they explained why. And torture is even as defined as unjustifiable pain is even more vague, because when we look at all the ways our society allows us to put bark collars on dogs, they allow racing, they with the crops, they allow branding of an animal, they allow and none of this, like when you take pigs, little baby pigs, they cut their ears and they do it deeply enough so that it can't heal again back and close back up. They pull their teeth without anesthesia. They crop their tails. They do this thing called mulesing to sheep, which they take scissors and cut off their back side so that the hair won't grow and they won't get infected. I mean, we do very, very painful things to these animals without anesthesia, and they are accepted. Museling is not illegal in the United States. And what I am afraid of is that in the United States, we feel that a parent has the right of discipline of a child, and there is no provision in here for discipline of an animal. And this statute as written is so overly broad that unjustifiable pain and suffering, I mean, unjustifiable suffering, someone might think crating your dog is unjustifiable suffering because they personally see it that way. This is so broad as to not give an ordinary citizen notice of what is actually actionable. And I would also bring the court's attention to this. Every case that I've looked at with torture has a severe degree of depravity. It is not, and it doesn't come without bodily injury. I have not found a case that has no bodily injury. And so if this statute is broad enough, because pain is so broad, pain encompasses bodily injury and emotional injury. If it's so broad, you have now allowed the jury to, because of the breadth of the statute itself, to convict for what we would consider acceptable behavior in our society: crating, leashing, bark collars are sold, shock collars, shock prods. I mean, we don't treat animals the same way that this statute is as written, the breadth of its statute could reach. Hold on one second. Yeah, and then also when you look at the term for torture, it says includes. It doesn't say is any act. So it's even more broad. They leave it so broad that I do not think an ordinary citizen can fairly know what this statute's limited to. Now, finally, what I wanted to bring the court's attention to is the very last section of our paper, of the memorandum, and it talks about whether this is a result of the conduct crime or a nature of the conduct crime. And that really matters for two reasons. One, if it's nature of the conduct, which is what the committee in their notes believed it was, then you can't recklessly engage in the nature of a conduct. And so we would ask for the recklessly to be struck. However, the committee also noted that it might be, if it's seen as a result of the conduct crime, then you have to have a result And in here, all they did is provide the conduct. They did not limit it by giving the result that we are supposed to be defending against. And so the indictment as pled would not be sufficient under result of the conduct to proceed. And we would ask that it be quashed for that reason. There's one last thing. Where's the motion? Sorry. And then finally, I would argue that the way the indictment is pled in and of itself shows that it's legally insufficient to be to prove torture, because it does not provide any accusation of what pain was suffered or that there was bodily pain or injury. And therefore, because all they've said is repeatedly striking, and by law, by common sense, we've seen that our society accepts horse racing and beating of horses with hard stuff, that I think that on its face, it is insufficient as pled to prove torture. It needs something more than just repeatedly striking a dog in order to constitute torture. Okay. Thank you, Your Honor.
All right. State.
Your Honor, defense keeps mentioning horses in the acts that we commit against these types of animals. However, those are livestock animals. In this case, we're dealing with non-livestock animals. These are typically in this case, cats, dogs, those kinds of things that aren't subject to the same kind of normal use and practices like a horse would be, as well as the argument about the result of conduct. She stated that we need to have a result. In this case, the result of the result would be torture to the animal by the conduct of repeatedly striking it. And then as well, the case that was provided, I don't think is applicable here just because of the facts that we have.
All right. In the Stevens case, is that relating to First Amendment rights and the violation of First Amendment rights?
So it is a First Amendment rights case, but their interpretation of that statute as being vague is what the analysis.
But isn't it because though they were saying that it's a violation of First Amendment rights?
Well,
to depict certain photos, and it wasn't necessarily about the acts against an animal. It was more about the right to free speech.
I think the bigger part of that, Your Honor, was that the statute in that case criminalized non-culpable conduct. And the court discussed that at the end when they say that this statute is so broad to even encompass, in that case, hunting videos or something that's non-culpable. The statute was so broad, similar to, what we're dealing with here, to encompass and criminalize non-culpable conduct. And I think that the issue is the same here, and that statute was even more specific than a good deal more specific than this statute.
But it's about First Amendment rights. I understand that sometimes you will have appellate courts. They will make a ruling on the issue that is specifically before them. And then you may have other members of appellate courts who will do a dissenting opinion or a consenting opinion, and then they want to add things that's not really about the issue at hand, but more as a signal to everybody to say, hey, this is what we're considering in general. But that case is about First Amendment rights and whether or not you could post videos of people being cruel to animals. Wasn't that whole statute related to the posting of videos and not necessarily about what we're here for today?
Well, in effect, that was the intent of the statute, was to ban crush videos of animals. But in practice, and when applying the statute as broadly as the court found that that statute was written, it encompassed a lot more than just animal crush videos, including, like I said, hunting videos, other things that, you know, are generally accepted practices that, you know, we would consider non-culpable. And I think that's the bigger issue with it. It encompassed more and criminalized more conduct than necessary, without, you know, a level of specificity to give the average person notice of, you know, what conduct that the law is criminalizing. And I think that's what the problem was in that case. I think that's what the problem is here.
Oh. Just one moment. Let me review some law.
Your Honor, I needed to add one last thing because I do believe this also triggers First Amendment protection. While it's not.
Well, just one moment, and then I'll let you say that. So with regards to the Stevens case, it appears that Congress changed the law and they made it a crime to knowingly create, sell, market, advertise, exchange, or distribute any Animal Crush video. And then they define what Animal Crush video is, that depicts actual conduct in which one or more non-human animals is intentionally crushed, burned, drowned, suffocated, impaled, or otherwise subjected to serious bodily injury, and two, is obscene. So they address that. But in this case, the Stevens case, it was about First Amendment rights. And you say you want to address something with First Amendment rights here?
Yes, because conduct is also, First Amendment also reaches conduct. And in this instance, there are First Amendment rights. We have a right to conduct our lives in First Amendment, like in our actions, in our words, and there are words that are taken in this instance, as well as actions that substantiate or like back up the words that are used. And she has a right to express herself, and her belief of what is right and wrong as far as discipline is protected by First Amendment. Whether we agree with that or not, someone's position, they still have the right to express themselves. And here, I do believe it's broad enough to also trigger First Amendment rights because she's talking, she is expressing a position, and so in that regard, if you were to criminalize this, you'd also be triggering First Amendment rights of what someone believes, and it was on a video that is then publicized.
All right, what do you mean she's talking and expressing an opinion? Because I don't see that in the indictment. Is that some fact issue?
Well, it is that it reaches that, like that First Amendment is going to be triggered because she does express an opinion as to why the dog is being repeatedly struck. And so it's all in the context of.
All right, when you say express opinion, I'm trying to understand. I'm sorry for interrupting you, but I'm trying to understand your argument. When you say she's expressing an opinion, are you speaking about your client?
Yes, there is in this case, there's an opinion stated. So this case is broader than just act. It's also speech, it's conduct, and repeatedly striking is a conduct in regards to discipline. And so discipline is protected by the First Amendment. You have the right to discipline and speak your discipline and to conduct your discipline.
Okay, I'm sorry. I'm trying to understand your argument because it appears that this is beyond the indictment, but are you saying that your client made some statements in its protected speech?
Yes.
All right, so does that go with the voluntariness of her statement argument?
No, that is a separate.
I don't see how the court is legally allowed to go outside of the indictment when you're saying a motion to quash, because now you're bringing in facts that are not in the motion I'm sorry, that are not in the indictment, because nowhere in the indictment does it state that there was a film. Nowhere in the indictment does it state that your client gave statements. So it appears to the court that what you're arguing now are fact issues. If the court denies your motion, they're fact issues for the jury, not for a motion to quash.
And I understand the court's position and agree that that was probably more as unconstitutional as applied argument that would be more appropriate at the end of a case than right now, when we're just looking at the face of the document of the indictment and the statute. But I would just say that repeatedly striking a dog is conduct, and conduct is protected by the First Amendment.
So you're saying striking at a dog is a form of speech?
Yes.
All
Because
right.
it's a form of conduct that it is by its essence related to discipline, care, control of your animal.
So then any type of conduct, be it against an animal or a human, then would be a form of speech.
It could be, but it could also not be a protected form of speech. That's possible.
All right, State, she's saying striking an animal is a form of speech and it's protected.
Your Honor, we were just asking you to look at the indictment on its face. We haven't alleged anything about discipline, anything about speech, anything about a video. We've merely alleged torture. By repeatedly striking a dog, we would assert to the court that regulation of conduct only implicates the First Amendment if it qualifies as expressive conduct akin to speech. But I don't see how it applies here, really.
All right. All right. With regards to the motion to quash, the court has heard arguments from both sides. The court has reviewed the case law that has been submitted to court. The motion to quash will be denied. All right. Then the next thing, let me see. The motion in limine regarding social media and news coverage. What I can tell the parties, people always assume that I know facts about a case. I don't know any facts about the case, believe it or not. I just read a lot instead of watching a lot of news. So I'm reading your motion in limine regarding social media and news coverage. Just give me a moment. All right. So with regard to news coverage, this is what the court proposes. And if anyone has any objections, let the court know. So usually what I will do, if you all will give me some information about the case, and if you both can craft a question, because I don't know any of the facts of this case, if you can craft a question that you all both approve of, I will ask the jury if they ever heard of this case before, right? Because I don't know where this is alleged to have taken place. I don't know anything about this case. So if you all would give me a question perhaps that you all would like me to ask the jury about whether or not they've seen anything regarding this case, then I will do that. So is there any objection to that?
There's not, and that's kind of what I set out in the second paragraph is
Mhm.
kind of my hypothetical of how it might be addressed.
Yes. So if you all will confer on that, and then we can put on the record the question that you all propose the court ask, and I'll ask that question. But if I had more alleged facts about this case, I would have a better idea of what question to ask the juror. But we can most definitely make sure that they haven't heard anything. And then if they have just stated that they've heard something, I'll question them separately.
Thank you. Yeah. That way, my concern was poisoning the jury for someone saying like everything they saw.
Okay.
And Your Honor, if I can, with the state's permission, just tell her just briefly the social media extent. Okay. So there was an alleged video taken of an incident in which it's claimed that Miss Miller struck the dog 15 to 17 times. And then it's posted all over social media. And there's been death threats, gang rape threats, and everything under that. It's been on the news. It's, I don't know, Facebook. I mean, and so my concern is just that I don't know exactly how.
Well, here's the thing. If you all get together on a question, in my mind, currently, I'm thinking just asking them, one, if they know your client, two, if they've seen any type of video in Bexar County, because I'm assuming this happened in Bexar County, because otherwise we wouldn't be here, or it's alleged to have happened in Bexar County. And I can just ask them if they are aware or have seen any videos where someone is alleged to be striking a dog.
Okay.
So that's what I'm thinking along the lines of having that. But again, if you all confer and decide on a question, we can discuss how the question is presented to the jury.
Okay. Thank you.
You're welcome. And I'll want you all to do that before you leave today.
Yes.
All right. The next thing is the first motion in limine. And it has to do with extraneous offenses or bad acts.
Yes, and specifically, what defense, well, we've filed a 404B and not received any response from the state on that. But we want to make sure that they're not mentioning, there is some reference by one of the witnesses that they had seen similar conduct before, but no details, dates, specifics have ever been given to us. And so we would want to have a hearing outside the presence of the jury before that is even mentioned.
All right, state, is there any 404B in this case?
No, Your Honor.
All right, so there will be no 404B.
Okay.
All right. And then
there's also, on that same vein, a removal hearing. And I believe that that is a separate and apart from this proceeding. They have different standards. And I don't know if it's an extraneous offense, but in regards to that removal hearing, I do not believe that the outcome of that
you
hearing
mean the removal of the
animal
Okay.
is relevant to this. So I would ask that, as I see it kind of as if it's not extraneous offense, it's definitely what they need for that is different from what they need here.
State, do you have any intention of bringing in evidence that the animal was removed from her care?
I think possibly, Judge, if it does become relevant throughout the course of trial.
All right, so the only potential way I see maybe it would come in is if, I don't know again about this case, unless somebody had to I know you're talking about a removal where, I believe you're talking about a removal where the animal was not returned to her.
Correct.
So removal as far as, I don't know if the animal was taken to the vet, the court considers that a different type of removal. But if you all are intending to ask any questions about the animal being permanently removed from her, then we'll need to have a hearing outside the presence of the jury. And if you think the door has been opened, we'll need to have a hearing outside the presence of the jury on that. But if you're talking about removal in that someone took the animal to a veterinarian, then that's completely different. But the legal removal, you'll all have to approach on. Does everyone understand?
Yes, and I agree with that analysis as well. We're not trying to say object to the removal to see the vet part.
Okay. All right, and then next, there's a motion in limine regarding Dr. Gottbetter.
Yes, and there's actually two. She's part of the original motion in limine because that had to do with a Daubert, and we also have filed a Nino hearing motion now as well. But the basis of that is that the state, we filed a 702 request, and we asked specifically for the disclosure of an expert, and also 702 requires the nature of what they're going to testify to. And we did not receive any notice at all at any point from what she was going to testify to. So we object to them getting into any of that before we have a hearing outside the presence of the jury.
Right, we'll have a hearing outside the presence of the jury.
And then the other, there's another motion in limine that's filed more specifically to her testimony as a lay witness. So expert versus lay witness.
All right, so when you say motion in limine, I want to make sure I have your motion in limine. So I do have the general motion in limine that's titled motion in limine. And then I have the more specific motion in limine that's regarding Dr. Gottbetter.
So if number 4 on the general motion in limine is
Mhm.
really more specifically going to the expert
Okay.
portion of her testimony. The one that was filed late last night in regards to a separate motion in limine that just deals with her is more to her specific knowledge of the case, and our concern that it will mislead the jury. She does not see the dog until 10 days later.
Mhm.
And so telling jurors what happened or what she observes 10 days later when we have not been provided any evidence as to where the dog was housed, who had the dog, if that can even be connected to my client. We would just want to have a hearing to see if that there's even any relevance to it, if it is overly prejudicial because of that break in time, because there is going to be a doctor who sees the dog within 24 hours and declares that the dog is apparently healthy. Then 10 days later, we have a Dr. Gottbetter that comes on, sees the dog, and makes some observations that I don't know are going to be relevant because of the break in time to whether or not what my client did to a material fact in this case.
Okay. All right, we'll have a hearing outside the presence of the jury.
Okay, thank you.
You're welcome. Does anybody have a paper clip over there?
Here, do you need one?
Yes, oh, they have one. Thank you.
Okay.
Thanks. All right, then the next motion that the court has is a voluntariness of any admission or confession.
So, Your Honor, I don't know, that is not ripe right now. I did speak with the state last night before we left, and they said they're not intending to get into any statements after she was taken into custody. So unless we need to approach that, at this point, I'm not gonna pursue it.
All right, is there any other motion?
No, not at this time.
All right, so this is what we'll do. Norma, can you see what trials we have for the week of September 15th? And so, just let me know. We'll make sure.
I have like 4 trials that week. The only reason I know it is because I have 4 trials. So.
Oh, no, let me know. The only thing is, one, I anticipate that this trial may go longer than anyone anticipates, potentially. And so to start now, I don't know if that's possible. And then the first week in September, I have a judicial conference that I have to go to. And then the second week in September, the September 8th, I have jury duty. So I don't know, maybe I can be on the jury, but the judge on the jury. So so there's a visiting judge for that week. I always tell everyone, you need to serve on a jury. So how would it be right for me to say, no, I'm a judge, I can't do this? So that's what I'll be doing. So
can I ask if you're here on the week of the 22nd?
Yes. I mean, I'll be here the week from the 15th through, well, for the remaining of the year. But the 22nd, you all will need to confer with Ms. Ferguson because I know we have some capital murder cases and murder trials that are up. So if you all would confer with Ms. Ferguson and Norma, the date you give them a Monday date so that we can have the hearing with regards to the expert. So we'll do the expert hearing after we have docket on Monday. So we'll do it in the afternoon.
Okay.
And so if y'all can see when your expert will be available, we'll have that in the afternoon of whatever Monday and go from there.
Judge, the only concern is just to contact our experts. Did you want us to get a specific date right now or?
Oh, if y'all want to call get some dates from Norma and then call your expert and see what Monday they're available. Or if whatever Monday they're available. Honestly, if they're available This week, we can do it this week, have a hearing. Or if they're available the week of the 15th, even though you say you have jury trials and everything, if for some reason they don't go, we can have the expert here that day. Would there be any objection? Because I know it's just for a hearing outside the presence of the jury. Would there be any objection to the expert for that hearing appearing by Zoom?
No, Your Honor.
All right, so that may make it easier if they can appear by Zoom.
Yes.
All right, so if you all will confer
Okay, thank you, Your Honor.
and then get a date for me, and then that will be the date.
All right.
So do you guys have a date?
29, Your Honor.
Okay.
You?
Oh, I'll be here. And Norma, that's the Monday?
Yeah.
All right, so on 9/29, we will have the Daubert hearing. That will be in the afternoon. So Norma, that'll be set at 1:30-ish. Well, 1:30-ish,
Okay.
because depends on how the morning docket goes. And then the next day, in the afternoon, we'll start with jury selection. All right.
Okay. And then, Jason,
Yes.
for some reason, she's not available on 9/29, 21.
So-
It's for some reason, that's.
Yeah,
We're
we're
gonna
gonna
do it
check.
beforehand.
It's a Daubert hearing for their expert.
Yeah. Exactly. I mean, I'm flexible, so
That'll
don't
be
think
Zoom
so.
anyway. So that one, right?
Yeah.
Yeah, okay.
Well, I mean, I'll be physically here.
No, we will too. We'll do it in front of the judge.
All right, thank y'all.
Thank you.
And then I will.
Oh, and then
get back
Norma,
with
she
you
needs a
on
reset form.
questions. I don't think she needs to
All right, thank
answer
you.
a month out, but on how she raises the question, y'all want to do it closer in time?
That's the way it
Oh,
goes.
there.
Okay.
Okay.
All right, so you're excused. Oh, wait, I need to get the reset for you to sign. Yes.
Enough time to look at it, I'll never better read, so it's so well.
No,
I can wait.
is it calling that?
Really, I was wondering, it's charged as a serious bodily injury, so it's a felony. Seeing if there's space for lesser included for the animal cruelty, the misdemeanor A. The dog's tied up, he's on tape, he hits the dog while the dog's tied up, you can see it clear as day. I don't know if it gets to the point of serious bodily injury. He said the dog had bit him previously, or had bit someone previously. He said he was tying it up
Yes.
because he had called the previous day to have the dog picked up by animal. The owner did.
Yes.
It's clear in the video.
Yes.
Tell you. Yeah, you wanted to say.
And Jody, if they're available by Zoom and you want them to Zoom in, I will let them know. Yes, if you want to do that now, we can
He's
do that
on the
now.
video.
They were.
Okay.
So
Yeah.
I can.
So-
they- one of them,
And
So I'm
you
gonna
also
be
sent
here
it
at 9.
to David.
Okay.
Show up, don't show up. then I
Well-
have bigger problems.
Well, let me ask you this. So do you want to call them, have them Zoom in? That way they don't have to show up
So that-
for tomorrow?
I only have, let me see. I'll-
Yeah, they may answer to that. Okay. I mean, if you want to do that or have them come in tomorrow at 9, either way is fine with the court.
I can get the Zoom information for tomorrow. I can get it.
Yes.